the sad eyes. Don't be discouraged, oh I realize.
When the contract fails, parties lose money, energy, time, opportunities, and reputation. Therefore, to understand it correctly, parties to the contracts should have knowledge about terms for the party and why they need them. Terms of the parties are words exchanged with each other in writing for the formal contract writing. That means to exchange conditions with reciprocal behaviors, promising to exchange with each other in fair shares, giving and returning equally, obligation to give, and then there are rights of the giver, obligation to receive, and there's also rights in order to protect the other party. Reciprocal, in short. The second thing is terms of the law. Whatever parties agree, they need to be comply with the laws. That's the reason why there's a standard check and there's consistency checks against the national law of Cambodia. The current law, known to be very well known to control personal contracting, is Civil Code of Cambodia. The law provides that when there is gaps in a party's laws, which is the contract, the laws will step in and advises what to follow. And therefore, there are two parts. One is obligation requirements, which means the parties' terms have to or have obligation to be complied with the terms of the law. And this is especially when individual right or party rights is infringed or is breached so clearly that the law wishes to intervene. And the law requires parties to treat each other to be seen fairly and in due course. The other things about terms of the laws that we need to know, to have knowledge of, is that when the law is open, when the law gives options to parties to choose what terms they need to give to the other party, and what terms they need to be bound by. And this is important also because there are provisions of the law which give these options. And when the law is silent, parties are presumed to be able to choose their own terms. But when things happen, they need to think about fairness. They need, therefore, in the drafting of the terms, they need to be well aware of the consequences that might happen. And that comes into the third thing, which is the need to know and the need to balance between parties' own terms and the terms provided by the laws. When these two things meet, people will have fair share in what they're going to do together, in the transaction that they're going to commit to each other. And if parties depend on themselves to compare their own terms and to check against the law, suppose they are lay people which they're not expertised, they don't have enough background in the legal studies, then their contracting is swayed by this sort of knowledge. And therefore, they can depend on legal experts' knowledge of thorough reading of the codes and other laws that are relevant in order to decide on how they're going to go together in this long commitment, the implementation commitment. And if things are not resolved, the conflicting terms may be well brought to the court, and the court will decide based on the interpretation of fairness, fair shares, which are ruled mostly by the state law. And the court is where the state laws are like to be used the most.
You with the sad.